days. And in August of 2017, he signed a settlement agreement with the Los Angeles Police Department expressly stating he would abstain from using alcohol for a period of 4 years. 4 years and a few months later, on April 30th, 2022, Mr. Fillmore was off duty and driving an unmarked LAPD detective vehicle. While driving southbound on Circle J Ranch Road at a high rate of speed, Detective Fillmore was involved in a vehicle accident. Detective Fillmore's police vehicle collided with the rear of a parked vehicle, causing that vehicle in turn to collide with the vehicle in front of it. Detective Fillmore's unmarked police vehicle was totaled, and the two parked cars received major damage. Detective Fillmore was pinned in the vehicle and sustained a broken wrist and ultimately required surgery for that injury. Los Angeles County Sheriff's deputies went to the hospital and determined Detective Fillmore had been drinking and driving under the influence in his unmarked police vehicle. A blood sample was taken around 2 hours and 45 minutes after the vehicle accident. At that point, Detective Fillmore was found to have a blood alcohol content of 0.18%. Again, this is well above the legal limit of 0.08. Detective Fillmore admitted to the deputy he had been the driver and sole occupant of the vehicle. He admitted he had been driving at a high rate of speed, and he admitted he had been drinking prior to driving. In March of this year, Detective Fillmore was relieved of duty by the LAPD. Detective Fillmore still shows to be employed by the Los Angeles Police Department and has been directed to a Board of Rights, which is scheduled for April of next year. April of this year, Detective Fillmore pled no contest to his second misdemeanor charge of driving under the influence of alcohol with a blood content concentration of 0.08 or greater. Detective Fillmore received 5 years summary probation, 15 days in jail, and a fine of $500 or 4 additional days in jail. Detective Fillmore was also ordered to complete an 18-month alcohol education program. Detective Fillmore's actions have resulted in the destruction of city-owned property, destruction of private property, and caused him to receive a serious injury. He's been convicted of driving under the influence twice while employed as a detective for the Los Angeles Police Department. The facts I've just relayed support the division's findings that Detective James Fillmore was involved in serious misconduct, specifically acts that violate the law that are sufficiently egregious to be inconsistent with a peace officer's obligation to uphold the law and respect the rights of the public. For purposes of the division's analysis, clear and convincing evidence means evidence of a charge is clear and convincing so long as there is a high probability that the charge is true. The evidence need not establish a fact beyond a reasonable doubt. I'd like to take one last moment to make a quick correction to the record. In the document I've drafted called the Investigative Summary of the Findings, there's a typo, and that's on the date that Detective Fillmore received his first DUI. In 2 locations in that document, it lists the date as July 10th, 2016. That should be February 27th, 2016. With that, I'm happy to answer any questions that the board may have.
Thank you. That date change does not affect the fact that it was just a few months after the agreement was signed. So he was told for 4 years, and we all read the terms and conditions of that agreement. And then about 9 months later, he violated again. Is that correct?
Madam Chair, the date change was on the first DUI, so it has no relevance to the 4 year.
Okay,
period.
so the second one, and
Correct.
Therefore the timing is the same as to the plea, as well as the amount of time that went by that he was put on those restrictions. Okay, thank you. Okay, board, questions, comments?
I also see Crawford. I also see that he was charged for fast driving under the influence. Was he charged with it, or?
I believe he was charged with it, but he did not, that was not part of his plea.
That's not part of his plea. So, and the courts found him guilty or not guilty?
He pled no contest.
And no contest on him, okay. Okay, and you said he received 15 days, 5 years, and 18 months for the second DUI, correct?
So he received 5 years of summary probation,
Okay,
15 days in jail, and then he had a fine. And then there was an 18-month alcohol education program that was also part of that plea.
and I assume his license was suspended, correct?
That's correct.
How long was his license suspended?
That I don't know.
Okay.
I do have a question.
Yes, just a comment in response. My position on this board is I was brought in under the title of attorney. And I can tell you that having worked in the district attorney's office for 32 and a half years, two things are generally true. One is when someone pleads to one of the counts, either the A or the B, traditionally district attorney's office throughout the state dismiss the other. The other was question you had about, what was the second point you made? One was on the plea and the other was, do you remember? It was a long time ago. Okay.
No, I reiterated, what the second DUI, what he received. And then I asked about his license being
Right.
revoked. and he said he
Okay.
couldn't.
There was another point, but it's not significant, but I wanted to at least respond from my history. Yes, more comments or questions?
Laura, just on page 127 of the materials that were put together for us, I see that there's a paragraph that talks about the embarrassment and contrition displayed by the officer, or the detective, forgive me. And I had some questions. So was there any, do you know anything about the personal issues that were discussed that led to his behavior? And do you know any of the activities that he said that were pointed out that, you know, the positive life changes that he made? Can you expand on that, or is it what we have before us?
Yeah, what I have is what's in the record. That was what was used to find our clear and convincing evidence. I don't have any further on that conversation.
I also noted from the report that I thought the alcohol that was found in his car, the small bottles of variety of liqueurs, they were all small, but they were in fact varying sizes.
There were varying sizes, varying small sizes.
Okay. And those bottles of alcohol bottles of alcohol like those were found during both arrests?
No, just during the first.
Just the
arrest.
primary one?
That's
Okay,
correct.
thank you. Yes.
Like Glazer, in the report, it says that he was driving his vehicle at a high rate of speed. Do you have any more specific information on that? I gather that that was based on the impact with the other vehicles, but do we know anything more about his driving?
No, sir. There's a 25-mile-per-hour zone where he got in an accident and he totaled his vehicle. I don't know how high a speed he was driving, and I don't know that that was ever determined. It was high enough for him to total his vehicle and cause two other vehicles to sustain major damage. That's all I have at that point.
Crawford, I have one more question.
Please.
You said, I mean, well, in the report, it states, no, you didn't say, but in the report that he was driving an unmarked,
Detective's car.
detective's car. What is the policy as far as detectives taking cars home, or do they keep them at home, or is there any reason other than outside of work that sometimes that they do drive the cars?
Yeah, I want to be careful not to speak to any of the policies of the
Okay.
PD. Those weren't necessarily used to find and determine clear and convincing evidence in this point. I can tell you that it's never been that ambiguous that driving under the influence of alcohol in a police car is not an appropriate.
I was trying to
use.
get his mindset.
Yeah, not sure, but yeah, that's never.
That statement, yeah,
it's-
I
it's
saw
in-
that.
Yeah, so. I think, if I can ask too also, the Johnson, by the way. I remember reading that he also tried to, I guess I can use the word bribe the arresting officer to not allow this to be known that he was arrested and had this level of alcohol in his system.
One of the allegations from the agency was that he tried to use his official position to gain favor after his arrest. To what extent that happened, I'm not certain. The facts that we used in this case to show an egregious act had occurred was the fact that we factually have a repeated act. We have 2 DUIs. We have an officer who was driving a police vehicle under the influence of alcohol. 2 2 hours and 45 minutes or thereabouts after after the accident, his blood sample was taken and returned at 0.18%, which is over 200% more than the legal limit. The fact that he caused an injury to himself, the fact that he damaged city-owned property, the fact that he damaged 2 separate people's vehicles. This was in a residential area. Those are the things that we're using to help establish the egregious nature of this particular act. There are the other parts that you bring up about the question as to whether he had permission to drive the vehicle, the question as to how he tried to gain favor to, maybe get a lesser charge or something to that effect. That's unclear with the record we were provided during investigation. Just bring it back to the facts that we're using to establish clear and convincing.
There was no evidence presented that he bribed someone, but it was that he used his badge to influence. Is that correct?
Potentially, he may have shown his badge and that may have been interpreted as an attempt to gain favor, or it may have been the fact that he was a peace officer and he felt compelled to show his badge.
Mr. Johnson, you may consider anything in the report in forming your opinion. The point I wanted to make before was there were 2.5 hours went by from the time he was driving until the time he had a blood alcohol level of 0.012. And there was an expert who opined what his blood alcohol level was the time that he was driving. Is that correct?
There was a blood alcohol expert, an expert in extrapolating blood alcohol content. That expert used a formula for the first DUI and provided that. I used that same formula for the second DUI, which would have put him around the 0.24 to 0.22, around 15 minutes prior to the accident. Correct.
Right.
That's correct.
Okay.
Yeah.
Any other questions about that? Yes.
Clavo. Oh. For clarity purposes, the first DUI was where the alcohol containers were found in, but not in number 2 DUI.
That's correct, ma'am.
Thank you.
Laura, I have a question. As this process is new, I don't know as the investigator from Post, are you permitted or allowed, I don't know the right terminology, to move forward, or was it considered a recommendation for suspension, or this was solely, your thought was this was a revocation case?
Yeah, the division's findings support there's clear and convincing evidence that serious misconduct occurred. The egregious nature kind of speaks to that. There's several reasons. First, it's not his first DUI. It's his second while employed as a peace officer. Second, the severity of the events has increased rather than decreased. In his second DUI, Detective Fillmore totaled a police car, caused extensive damage to 2 privately owned vehicles, and caused an injury to himself that required surgery. Third point would be that Detective Fillmore had been suspended administratively after his first DUI, and likely his license was suspended in that case as well. And neither of those suspensions prevented his second DUI. So it shows that suspension might not be the appropriate avenue. And finally, these criminal acts show wanton disregard for public safety, which we find incongruous with being a peace officer. Hence the recommendation to revoke.
So thank you for clarifying that. So they did consider that in their recommendation. And of course, as a board member, you can still make a motion that be appropriate. Any other questions or comments?
Clavo, one more
Heard.
question. Do we
Crawford.
know if he was offered any EAP or any services for his drinking behavior and habits?
That's unclear. That may be part of the settlement agreement. He was likely offered EAP. The fact that he had a alcohol education program, those tend to parallel in nature the type of things that one might get from an EAP, just source. So
Thank
he
you.
did receive 2 rounds of alcohol education after each
But to be clear, the first time he had a DUI, had to by law go to the DUI school for a first offender. The second time he had the DUI, he had to go for a second offender. So there were two forms of education after that. Additionally, as part of the terms and conditions of his first DUI, the agency insisted that, I believe counseling was one of the provisions that they also insisted upon, that he begin and complete counseling session. Is that correct?
That is correct.
Okay, so hopefully that answers your question.
Yes, thank you.
Any other questions or of this?
Robert, and I know that you said earlier it was about policy. That's, yeah, that I'm interested in seeing, and maybe we'll do that in closed section, the policy of now
Let me
maybe,
suggest to you, we don't have to go into closed session, or we can go into closed session with this case. The first case, the primary reason we went into closed session was because the nature of the videos. So there is a provision that would allow us to go into closed session for the deliberation process, or we could stay out here. Please go on.
so, and maybe this is to my attorney, Christopher. I'm interested in seeing the policy of each, a post regarding officers and the misconduct, and also the policy of, the station, former DOD, generally, if you get like a first DUI, you don't get a second option. And so maybe somewhere within the body of the policy, I don't know what it may read, 1, 2, or 3 offenses.
I could speak to Post. Post wouldn't have a policy on something like that.
Okay.
The agency may or may not. Do you happen to know if the agency, if there was a policy on what would happen in first or second offenses on DUIs?
No, ma'am. Colloquially, it's referred to as the bail schedule, right? With punishment imposed by a organization. That bail schedule changes from organization to organization, and I think it's taken on a case-by-case basis. What I can say in this case is that Detective Fillmore was relieved of duty, and he was ordered to a board of rights, which happens next year in April. So the suggested outcome is termination. He's been like de facto terminated, waiting for his board of rights. So.
Any other questions?
Just in my experience, I don't even know if the Police Officer Bill of Rights would agree to this, but we've never had a chart of what you get for different disciplines. I mean, there's the unwritten. For instance, in my agency, the first DUI was 5 days. The second was termination. Unfortunately, I never had to do the second, but I kind of think, and maybe Toby or Christopher, no, I don't think the Police Officer Bill of Rights would allow you to have like a matrix that if you did this, this is what you get. I mean, because each case is supposed to be dealt with individually.
Would you like Mr. Darden to approach and you can ask him?
Excuse me?
Would you like Mr. Darden to approach and you can ask him that question?
No.
Okay. Any other questions or comments? Any questions for the attorney? Okay, very much. So now I would like to know if any member would like to go into closed session, or if you'd like to deliberate this out here. I'm sorry, what?
Public comment.
Oh, I'm sorry. I completely forgot public comment. So is there someone who would like to make public comment? Thank you. Good morning, and it's up to you if you'd like to introduce yourself. Good morning, Ms. Wilcox.
Good
And I
morning.
apologize for having stalled on that.
No, that's okay. It's new. We're all learning. I'm Leslie Wilcox. I am a union attorney for the Los Angeles Police Protective League, and I represent Detective Fillmore in this post SB2 matter with POSAB. I would like to address a couple of issues that the board has asked questions about. I may be slightly more familiar with that process. I would like, Mr. Johnson, for you to know that LAPD policy requires all of their employees to identify themselves as an officer or an employee of the Los Angeles Police Department anytime they are contacted by another law enforcement agency, which I think the law enforcement consultant, that presentation of their identification sometimes can be misinterpreted. That is definitely something that Detective Fillmore is disputing, just so that you're aware of the department's policy requiring that. And Ms. Crawford, I also wanted to let you know that Detective Fillmore disputes that he did not have authorization to have that detective car at home. That's one of the issues that will be appealed in his Board of Rights that is scheduled for April of 2024. Regarding the discipline matrix, LAPD does have a penalty guideline that gives guidance to both their command staff in reaching a decision for proposed discipline in any of their cases for allegations of misconduct. And then once it is appealed either to a civilian or a sworn board for the Board of Rights, they are also given that penalty guideline, and it ranges anywhere from an official reprimand, which is a written penalty, with guidelines for suspension days all the way up to termination for various different categories of allegations of misconduct. And there would be a specific guideline for driving under the influence in this particular case, just so that you're aware of that. Someone asked what led to this. Detective Fillmore was in the process of dealing with 3 open homicide cases, had 3 people that he was searching for murder warrants. That's the reason he had the take-home car. He was in the middle of 2 murder trials and was up for a promotion to a detective 2, and learned shortly before this incident of the second DUI that they promoted someone that he had trained himself to that position. Thank you.
Counsel, would you mind sitting down? I think the mic carries better if you're sitting and
course.
pulled towards you.
Thank you.
And I'm sorry to interrupt.
That's okay. They were promoting someone that he had trained that had 10 years less experience than him. And given the amount of time that he had been with the department and the work that he was doing, this was fairly devastating to him, and unfortunately triggered a relapse to his alcohol addiction, which led to the second DUI that we are here about. Since then, when he was taken to the hospital because he broke his wrist, immediately upon being released from the hospital, he went to an inpatient program for alcohol addiction and was there for 65 days and has been sober since. So I wanted to make sure the board was aware that he had addressed this situation in a different manner than had been addressed in 2016, and has been successful in maintaining his sobriety as a result of that intensive outpatient program that he went to straight from the hospital. Additionally, I am requesting that the board defer this matter until his Board of Rights. My understanding from the Post website is that if there is an appeal from the proposed discipline, that the board will wait until that discipline has become final before it moves forward with its own process. And in this case, the final discipline is not until a Board of Rights, in Detective Fillmore's case, makes a decision about the final discipline, and then the chief of police signs off on that decision. And that will be, I believe, on April 3rd. He has 3 days scheduled. So I'm requesting that this either be continued or deferred until a date after that, before this particular board makes its decision about whether or not to go forward with a suspension or a revocation, mainly because there will be a significant amount of evidence that will come out that may address some of this board's questions. But it is a de novo hearing, which involves multiple witnesses, cross-examination, closing argument, all of the body-worn video evidence from the agency that arrested Detective Fillmore. So it is a very extensive process that can shed some light about some of the questions that this board has raised today. And I think it would be most efficient if this board would defer that until his final discipline has been imposed, so that you have more detailed answers than the investigative summary that's been provided to you at this point. According to the frequently asked questions on the Post website, that my understanding of POSAB is that it will not undertake a revocation or decertification or suspension recommendation until the discipline is final. In Detective Fillmore's case, it is not final yet. As the law enforcement consultant told you, he is still technically a member of Los Angeles Police Department until that board makes that final decision in April of 2024.
Okay. I will ask counsel to respond to what the website says and the relationship between a Board of Rights hearing and this board's job in a moment. But let me ask you, you mentioned there's LAPD guideline. What is the guideline when someone suffers a second DUI?
It's 20 pages long, so I don't remember that one specifically. I believe.
Let me ask you, the guidelines is 20 pages long on what to do if someone has a second DUI? Oh, just the entire guideline? Okay, so you don't know?
I can pull it up for you
Okay,
if you'd like.
thank you.
One
Sure,
moment,
take
please.
your time.
Madam Chair, it's frequently asked question number 23, if that helps.
Oh, I think there's, okay, I appreciate the frequently asked question 23, and we'll take a look at that, but I think maybe I asked my question inartfully. I'm wondering what the LAPD guideline is on someone who suffers a second DUI.
Yes, I'm trying to pull up their
Okay.
guidelines.
Would you like us to take a 5-minute break or a 10-minute break and give you some more time?
I just found it. Thank you. I'm
Okay,
sorry.
excellent. Of course, you just found it. I
So, yes, of course, Murphy's Law.
Please take your time.
That's okay. There are different sections for driving and traffic collisions, specifically driving a city vehicle in violation of policy, resulting in a fatality or severe injury. I'm not sure that this technically would qualify as that, but a first offense can go from an official reprimand up to termination. And a second offense can go from 16 days suspended up to termination.
And in this case, we had serious injury to the driver. We had a wrist that required surgery and hospitalization for some period of time. So thank you for that. And then I have at least 3 people who can respond to your other question. We'll start with the Assistant Executive Director.
Thank you. The division objects to the request for a continuance. The continuance was not received until December 5th, which was after the matter was presented to the board and was posted on the Post website as a matter of public record. More importantly, to speak to the request for continuance in this matter, the Board of Rights hearing has no binding effect with respect to the board's recommendation regarding decertification and therefore should not be delayed. The evidentiary hearing that you heard today in terms of allowing mitigation and evidence and facts to be fully explored will happen before an administrative law judge with respect to the board's recommendation and forthcoming, the commission's recommendation. And therefore, this matter should not be continued or told. I respectfully request the board move forward with its decision or recommendation. Thank you.
Okay, thank you. Counsel, is there anything you'd like to respond to?
Not,
So you're familiar, he is counsel for this board, and then we
Understood.
also have counsel for Post.
Understood.
Okay.
yeah, so unless the board members have questions about what they were just instructed on, I concur with the thought that there is no relationship between the Board of Rights hearing and what this board is deciding. What this board is deciding is restricted to the investigation as described. There's no connection.
Thank you. And also the chief attorney for Post, Toby Darden, did you want to respond to any of that?
Thank you. Thank you, board members. The tolling provisions in the act refer to something that's a little bit different. There is a tolling provision